My name is Jack Humberg. I am the Chief Operating Officer for Boley Centers. Boley Centers is an organization that primarily serves individuals who have mental health related disabilities in the Tampa Bay area, in the Pinellas County, St. Pete, Clearwater. And I'm also the only employee of Pinellas Affordable Living, which is a separate corporation that does the affordable housing development. And so most of my time I'm spending developing affordable housing for people with disabilities in the Pinellas County area. But for the past 32 years, I have been the Florida affiliate for the Southeast ADA Center, helping people understand their rights and obligations under the ADA. Boley Centers has about 1,200 units of affordable housing in Pinellas County, all targeting individuals who are at or below 50% of the area median income, most of them below that, and with mental health related disabilities. And so we've been around since 1970 helping people with mental health disabilities live independently. More and more we're serving homeless individuals right off the street, trying to help them get stabilized. The Southeast ADA Center is one of 10 regional centers that provide technical assistance and training on the ADA. We do not do enforcement. We're simply trying to help people understand their rights as a person with a disability under the ADA and helping employers and Title II entities and private businesses understand their obligations under the ADA. So I don't do enforcement. You can say anything to me today. Nothing will get outside this room. What happens here stays here, as they say. So you can ask any question that you might have. This is session 4, so had a bunch of questions already, and I'm not afraid to say I don't know the answer to that. So if you have a question, please raise your hand, and we'll try to address them as we go along. We got a couple hours to cover these topics, and I want to be sure that you get from this session what you need and try to answer any questions that you might have. The grant is funded under the National Institute on Disability, Rehabilitation Research, and Independent Living, and that's through the U.S. Department of Health and Human Services, and that is my commercial. So at its core, the Americans with Disabilities Act is a civil rights law. It provides civil rights for people with disabilities, and not until 1990 did we have a federal law that says you cannot discriminate against a person with a disability because of that disability in the provision of your services and in employment and in private business under the ADA. And so, yes, if you go back to the 70s, and Section 504 of the Rehabilitation Act of 1973 said if you get federal financial assistance, like most counties do, but if you get federal financial assistance, you cannot discriminate on the basis of disability. But if you don't get federal financial assistance, there was no coverage until the Americans with Disabilities Act was passed in 1990. And finally, there we have a law that provides protections for people with disabilities, and it extends to the private sector as well. So it doesn't matter whether you're receiving federal dollars or not, you have obligations under the ADA to not discriminate against persons with disabilities. This law was signed into effect in 1990 on July 26th by President George Bush, the first George Bush, and he said that this is the world's first comprehensive declaration of equality for people with disabilities. So we finally have a federal law providing protection. I'm sure you're going to ask or think, why is he reading the slides? I do that because as an accommodation to individuals in the room who may have visual impairments and not able to see the slides, so I will read some of these slides as we go along today, and I hope you'll bear with me. We try to accommodate individuals with visual impairments and hearing impairments by using the PA system, so hopefully you can hear and see what's going on. So there are about It's estimated that 1 in 5 Americans has a disability. So in a room this size with this many people, think how many people in this room may have a disability. Think about the people in your families who have disabilities. About 1 in 5 have what would be considered a qualified disability under the ADA. Of those, 35%, or around 22 million, are of prime working age. And if you look at the statistics for unemployment, the unemployment among people with disabilities is at least double, maybe more than that, of what it is among individuals without disabilities. So there is still discrimination alive and well in our country, discriminating against people with disabilities, people who refuse to provide accommodations, and so we continue our work to help people understand their rights and obligations under the ADA and help employers understand how to provide reasonable accommodations to help people with disabilities to be in the workforce and be productive citizens and taxpayers. So before I go further, I want to talk about who's entitled to protection under the ADA. So with regard to the individual, it is a person with a physical or a mental impairment that substantially limits one or more of a major life activity. All right, so it's a physical or a mental impairment. Think about the people in your life, or yourself, or your family. Lots of us have impairments. Now that I'm old, I need my glasses to read the fine print. I have a little hearing loss. Those are impairments. But do they rise to the level of a disability? Do they rise to the level of substantially limiting in a major life activity? Again, think about the people in your lives. They may have impairments, but are they disabled by those impairments? Does it rise to the level of a substantial limitation in a major life activity? Major life activities can be all kinds of things. It could be seeing, could be hearing, could be walking, could be interacting with others. The people that we serve at Bowley Centers all have severe mental illness related disabilities. So what are the major life activities that impact them? It could be simply getting along with others, right? Taking supervision, being able to be in a group without disrupting the proceedings. Major life activities can be a variety of different things. So think about the impairments of the people in your life. Do they rise to the level of substantially limiting them in major life activities? Many times they don't rise to that level, and a lot of court cases have hinged on this question of, is this a person with a disability? Does it rise to the level of a substantial limitation? Yes, this person has an impairment. I need my glasses, but I still drive, I still work, I still take care of my family and myself. It doesn't rise to the level of a substantial limitation. Let's assume my vision gets worse. Maybe next year I'm not able to drive. I'm declared legally blind, whatever that means. And I'm no longer able to drive or take care of myself or work. Now we're talking about an impairment that substantially limits a major life activity. Make sense? Not every impairment rises to that level. Many do, but not every impairment rises to the level of a disability. So the ADA is comprised of 5 different titles. Title I covers employment, and that's what we're going to spend the next 45, 50 minutes on, talking about the employment provisions of the ADA. Title II covers public entities like the county, the school system, the jail system, public entities. Title III covers places of public accommodation. What is that? A place of public accommodation is a private business that invites the public to come in and buy their goods and services. A place like public supermarket, for example. Here we have Congress saying to a private business, you can't discriminate against people with disabilities. And you have an obligation to remove barriers to your business. a private business that's not getting any federal dollars, but they have an obligation under the Title III obligations under the ADA to remove barriers that are readily achievable for them to do so until their business is accessible. We're not going to talk a lot about Title III, but it's important to understand that even in private business, there's no grandfather clause. The ADA doesn't say, oh, well, you were in business before the ADA, so you don't have to do anything. Wrong. There is no grandfather clause. If you are open to the public and you invite the public to come in, you have an obligation to remove barriers to your business until your business is accessible, and that's an ongoing obligation. It could take several years. It's not meant to put anybody out of business. It's meant to remove the barriers to the customers so that they can get the goods and services under Title III. And that's about all I'm going to say about Title III, unless you have questions. Title IV is the telecommunications provisions. Where you might run into that is you might get a phone call from the Florida Relay Service. Mandated under Title IV is a relay service that will relay telephone calls from someone who is deaf or speech impaired. They call the relay service, and that relay service will place that call for them. And so you might get a phone call from, this is operator 56 from the Florida Relay with a telephone call from John Doe. It's not a telemarketer. That's a legitimate relay service of someone with a disability trying to make that telephone call. And that's all I'm going to say about Title IV. Title V is a bunch of miscellaneous stuff, like who enforces what. The Equal Employment Opportunity Commission, EEOC, enforces Title I of the ADA. The Department of Justice enforces Titles II and III of the ADA. So if a complaint is filed against the county, they may file that complaint with the Department of Justice, saying I was discriminated against. The Department of Justice may assign that to one of the other federal agencies to do the investigation, depending on what the complaint is. For example, many years ago, I was working with the city of St. Petersburg, and there was a complaint filed against Tropicana Field, and it was filed with the Department of Justice, but they sent the Department of Interior down to do that investigation because of the nature of a sports facility. So if that case goes to court, you would be sued by the U.S. Department of Justice looking to right that wrong, assuming there was a wrong. Make sense? You with me? Everybody still with me? Hello? There's a lot of people in this room. This is like the biggest crowd we've had. This is the final of 4 sessions, so I'm repeating myself over and over. All right, so Title V covers the miscellaneous stuff, including at the time, it was the Department of Education, the Department of Education that was given the responsibility to provide technical assistance and training, and that funded the grant for the National ADA Centers and the regional centers, of which I'm here today representing the Southeast ADA Center. Title V also says who's enforcing. EEOC and Department of Justice are the enforcement agents. I list the contact information here because online you can get a wealth of information. The Title I information under eeoc.gov. There's a lot of great guidance there and information about your obligations under Title I of the ADA. If you have questions about that, I encourage you to go to eeoc.gov. And if you have questions about Title II, the Department of Justice's website is actually ada.gov, and they have also some excellent guidance documents there and research that's going on accessibility and building code issues, as well as on ada.gov. So I encourage you, if you have questions after today, go to those websites, or you can go to the Southeast ADA website and get more information. So, Title I, and I'm going to read some of these slides today just as an accommodation for anybody who can't see the slides. No covered entity shall discriminate against a qualified individual with a disability because of the disability of such individual in regard to the job application procedures, the hiring, advancement, or discharge of employees, employee compensation, job training, and other terms, conditions, and privileges of employment. So it covers the whole employment arena, from the time you advertise for that job. Are you doing that in an accessible manner? If I'm blind, can I read your advertisement? Can I find the posting for your job? If I'm a person with a disability, can I get your job postings, right? And it covers the whole job experience all the way up to retirement, including job application procedures, advancement, and employee compensation. So it covers anybody who has 15 or more employees. So a small mom and pop pizza store at the end of the street that has 5 or 10 employees are not covered under Title I of the ADA. They do not have obligations to accommodate their employees who have disabilities. If you have more than 15, then you do have those obligations, but a small business does not have an obligation to accommodate their employee under Title I of the ADA. If they're open to the public to sell their pizza, they still have obligations under Title III to be accessible to their customers, no matter how many employees they have. If you're open to the public, you have an obligation to remove barriers until your business is accessible, as I said earlier, right? But you don't have obligations under Title I if you're a small business. It covers private employers, state and local government employers, employment agencies, labor unions, and joint labor management committees. So you can't skirt your responsibilities by using a temporary service or, one of those employment services. I need a temporary employee, but don't send me somebody with a disability. In that situation, you both have obligations. Both the employer and the temp service would have obligations under the ADA to not discriminate against a person with a disability. Private membership clubs and Indian tribes are exempt from Title I of the ADA. And when I say private membership clubs, I'm not talking Sam's Club. I'm talking a true private club, right? So what is a qualified individual with a disability? That is an individual with a disability who satisfies the requisite skills, experience, and education requirements of the position that the person holds or desires, and who, with or without a reasonable accommodation, can perform the essential functions of the position. Okay, so let's look at that definition. It's an individual who satisfies the requisite skills, experience, and education. So if you require a bachelor's degree for this position that you're trying to fill, and an individual with a disability comes in, they may be very qualified, but they don't have the bachelor's degree, they're not eligible for the position. They're not qualified, right? If you require that this position type 50 words a minute, and an applicant comes in with a disability, they must be able to type 50 words a minute to be eligible to be qualified for the position. Now that may mean I need to provide an accommodation. Maybe I'm an amputee and I need a one-handed keyboard in order to type 50 words a minute, but I can do it if I have the right accommodation, all right? They're qualified if they can meet the requisite skills necessary for the job. Now, I had a question in one of the other sessions about, okay, so I have an applicant who's a one-handed, typist and can type 50 words a minute, but the next person that comes in can type 70 words a minute. Well, you can hire the most qualified person for your job. There is no requirement to lower your standards. If you require they be able to type at 50 words a minute and they can type, they meet the standard, but if a better applicant comes in with better qualifications, you can hire that person. You're not required to lower your standards for a person with a disability. You can have your standards and they need to meet those standards in order to be qualified for the position. Make sense? Okay, so with that said, the person needs to be able to perform the essential functions of the position, with or without a reasonable accommodation. That is the critical element. I must be able to perform the essential functions of the job. What are the essential functions of the job? Think about your job. What are the essential functions of your position? And depending on where you work and what you do, you can probably tick those off, right? But think about that for a second. What are the essential functions of your position? You must be able to perform those functions. And we've seen a lot of court cases under Title I of the ADA where there are existing employees. I've worked for this company for 25 or 30 years, right? I've done this job for many, many years, and now I've become disabled. I need to be accommodated. Okay, we try to accommodate that individual. Maybe we try 2 or 3 different reasonable accommodations that, we negotiate with them. We discuss with them what is necessary, and they're still unable to perform the essential function. If you are unable to perform the essential function of the job, with or without a reasonable accommodation, you're not qualified for your position. And so we've seen a lot of court cases, but with existing employees, and they have become disabled, try to accommodate them, they're unable to do the essential function of the position, they're no longer qualified. And they will lose that court case if they take it to court. Because at the end of the day, you must be able to perform the essential function of your position. Make sense? So talk a little bit about the hiring process and interviewing. You can certainly ask in the interview, these are the essential functions of this position. We want you to do X, Y, and Z. Can you perform those essential functions with or without a reasonable accommodation? You don't have to add the with or without an accommodation. Can you perform these essential functions? We want you to do X, Y, and Z. Can you do it? Now we have some marginal functions. Can you do those too? We certainly can ask those questions. You can ask questions about attendance. This job requires you to be here from 8 to 5, Monday through Friday. We want you in the office, in the business. Can you meet those attendance requirements? Simple question, right? You can ask about, you should not ask questions that would refer to an illness or a disability. And you don't want to ask, how much medical leave did you take last year? Because that could trigger an answer that's likely to elicit a disability-related response. You can ask, how much vacation did you take last year? How much time off did you take last year? That doesn't tell you whether I have a disability or not. But if you ask, how much medical leave did you take last year, that could trigger a disability-related response that you don't want to have at the interview process. Okay? What about medical exams? After extending a job offer, an employer can require a medical examination prior to the start of employment. The examination does not have to be directly job-related, but must be required of every applicant in the same job category. And the key is, if the employment offer is withdrawn due to the medical findings, the employer must be able to show that the rejection was job-related and that there was no reasonable accommodation that would enable the individual to perform the essential job functions. So, congratulations, you've got the job. I want you to start next week, but before you start, I want you to fill out this health questionnaire and go get a physical. And we do this for everybody in this position. You have to get a physical, all right? I get the physical back. And let's say I'm hiring for somebody who's going to be doing manual labor. We want them to lift, bales of hay. Just pick it. They're going to be lifting, moving things, physical labor. And the physical comes back and it says this person has had back surgery. And we've seen a lot of these cases where the employer immediately says, no, I'm rejecting you. Sorry, I'm rescinding the job offer. You've had back surgery. I don't want you. Well, before you rescind the job offer, you've got to consider whether you could accommodate that employee. Is there an accommodation that would allow that employee to perform the essential functions of the job? You've already determined this is the person you want for the job. They're the most qualified person. That's why we chose them. We get the physical. It's got back surgery or, whatever it might have. Before you can rescind that job offer and say, no, I'm not going to hire you because I got this medical information, I need to first consider, can I provide a reasonable accommodation that will allow this person to perform the essential functions of the position? Follow me? A disability inquiry is a question or series of questions that are likely to solicit information about a person's disability or related medical condition. Don't ask those ahead of time. What can you ask? You can ask how the person's doing, non-disability related impairments, whether a person can perform the essential job function, of course. You can ask about how much they drink, or do they use illegal drugs? And again, those are questions okay under the ADA. Obviously, the county has a human resources department, you need to follow the HR script, if you will, and follow the guidance that you get from your human resources department with the county. So I'll jump over this, but you don't want to ask, do you have a disability? You don't want to ask genetic information or prior workers' comp history. You don't want to ask about medication use during an interview. So you don't want to ask at that, did you file any workers' comp claims in your last employment? That's likely to trigger a disability-related response, and if I don't pick that person, then they can use that to say, I was rejected because of that. So the EEOC says there's 3 phases to employment. There's the pre-employment phase, where you should not be asking those questions. And then there's the pre-employment post-offer. So I've made a conditional offer, I get the medical information back, and then what do I do with that? I need to consider, can that person be reasonably accommodated, assuming that I get information that there is a disability. So can they be accommodated? And then employment, we're an existing employee. Let me say that we do job training for people with disabilities who are looking for work. And one of the things we tell them is, you are under no obligation to disclose your disability to a prospective employer or your existing employer. You're under no obligation to disclose that disability unless you're requesting a reasonable accommodation. If you request a reasonable accommodation of your employer, the employer can say, provide documentation that you have a disability, give us a doctor's note, and if I don't like that doctor's note, I can ask for a second opinion, right? I can get documentation because you have come to me requesting a reasonable accommodation, so I can get evidence that, yes, there's a disability, and what kind of accommodation might be necessary. So the only time you need to disclose is when you're asking for an accommodation, and then you can't, and so obviously in that situation, you're asking just that employee for documentation of their disability. Make sense? Still with me? Okay, I see some heads. Yeah, good. Okay, so what are the essential functions? Well, that means the primary job duties that are intrinsic to the job. Again, think about what are the essential functions of your position or the positions you're hiring for. They do not include marginal or peripheral functions that are incidental to the performance of the primary job duties. So why were you hired? Yes, there are other reasons. I think about things that I do, and I do some peripheral kinds of things. But for example, one of the essential functions of my job is to do this training today. Right? I go around and do training across the state. Now, at these days, I don't get a lot of training requests. Used to be pretty often. Now I get maybe one a month, maybe one every other month. But so it's not something that I do every day, but it is an essential function to my job that I need to be able to stand up in front of a group of people and talk for a couple hours about and have the knowledge of the ADA to be able to do that. So that's an essential function of my job. It's not something I do all the time. And think about your essential functions. You may have been hired because you have a very specific skill. How often do you do those? Maybe you do it every day, maybe you do it multiple times a day, or maybe you only do it every couple of months. But it's a specific skill that's essential to your position. If you can't do your essential functions, you're not qualified for the job. With or without a reasonable accommodation, you need to be able to do those essential functions. Have I nailed that? Have I kicked that horse enough? It's important to understand that, the essential functions are critical. A function may be essential if the position exists to perform that specific task. There may be a limited number of other employees available to perform the function or among whom the function can be distributed. There may be that the function is highly specialized and the person in that position is hired for special expertise or ability to perform it. Let's take that second example where there are a limited number of other employees available to perform the function or whom the function can be distributed. Let's take an office environment. Well, let's say we've got 5, I'll use the term clerk typists. That's kind of an antiquated title, but 5 clerk typists in an office. And one of the things that they do is they take phone calls and they route phone calls to other people in the office, right? One of those individuals is losing their hearing. And we've tried to accommodate them by providing an amplified phone. They have hearing aids and so on that they provided. That's a personal use item. But the telephone itself has been amplified, and it's still not working. They're not able to do it. Now, we have 4 other people in that office that do that same function. We could reassign that function to one of them, even though it may be considered an essential function. When there are other people to assign it to, we maybe give her or him additional duties to do something else that doesn't involve the phone, and we reassign that to the other 4 folks. Makes sense, right? Let's change the scenario and let's say there's only one position in that office that does that duty, and that individual is losing their hearing. So now it may be that that is an essential function for that one position, and there's no one else to reassign it to. They may no longer be qualified for their position because that is an essential function of their position. They can't do it. There's no one else you can reassign it to, and they need to be able to perform their essential function. Okay? A question? No? So, is it essential? What are the consequences of not requiring the person to perform that function? Also, the terms of a collective bargaining agreement could be a factor. You may have, a collective bargaining agreement that says these are the essential functions of this position, and anybody in this position must be able to perform those essential functions. And of course, the work experience of those who perform the job currently or in the past is good evidence about what is an essential function. And let me say that the employer determines what are essential functions. It's not the employee, it's the employer who gets to say, this is an essential function, you must be able to do it. Are job descriptions important? Well, the ADA does not require that there be job descriptions. It's certainly a good idea to have job descriptions that delineate what are essential functions and what are marginal functions. And you may have, they're important for defining the position, for employee recruiting and selection, developing compensation programs, and they're important for employee training and development to have good quality job descriptions that outline what are the essential functions of the job. It's not mandated by the ADA, however. So what's a reasonable accommodation? Well, an employer must provide reasonable accommodations to the known physical or mental limitations of a qualified applicant or employee with a disability. And as I said before, you are not obligated to disclose your disability unless you're asking for a reasonable accommodation. So an employer is not clairvoyant, of course. They're not going to know you have a disability, in many cases, hidden disabilities. They're not going to know that unless you disclose it to them, right? So I can't be held responsible for not providing an accommodation for somebody's disability if I'm not aware of it. And that certainly does happen. Just some accommodation facts. 70% of employees with disabilities never request an accommodation. You have people working for you right now, I'm sure, who have physical or mental impairments that substantially limit one or more of a major life activity that don't ask for accommodations, they just do their job, right? 56% of employers reporting that the accommodation didn't cost anything. They may have restructured a job, they may have reassigned answering that phone to somebody else. Didn't cost them a dime to do that. And 74% of employers report that the accommodations are effective. That means there are some that weren't effective, but the majority were. This is data that's a little bit dated. It's coming from 2009, the Job Accommodation Network. But the point is that most accommodations don't cost a lot. We accommodate people all the time, and it works. If employers have ever done anything differently to enable someone to stay in a job and be effective, that's providing an accommodation. So we provide lots of accommodations, not always related to a person with a disability. So a reasonable accommodation is a modification or adjustment to a job, an employment practice, or the work environment that makes it possible for an individual with a disability to enjoy an equal employment opportunity. And they're required in 3 areas. They're required in the application process. So let's assume we're hiring someone and the applicant says, emails you and says, I'm deaf and I need a sign language interpreter for the application process. I will not need an interpreter to do the essential functions of the job, but I need an interpreter just to get through the application process and the interview. Okay, so you have an obligation to provide reasonable accommodations to the application process. You may have an individual who is developmentally disabled and has difficulty filling out the application because of their disability. But you're hiring them to do, custodial work. They're going to, clean the parks or do something of that nature. They don't need any accommodation in order to do the job. They simply need accommodation to complete the application process and get through the hiring process. Make sense? Of course, the performance of essential job functions, which we've been talking about. And the third area is the enjoyment of equal benefits and privileges of employment. What does that mean? Well, you may not feel like it right now, but being here for this training program is a benefit of employment, right? If we had an individual who needed a sign language interpreter in order to participate in this training today, their employer has an obligation to provide that kind of accommodation. It's a benefit of employment. It's not an essential function, but it is a benefit of employment to be able to get training and to keep up with the training requirements of the job. And so having an accommodation that allows them to do that, like a sign language interpreter, is required under the ADA. It could be something simple like, the Christmas party, the annual Christmas party. We're going to have it in an inaccessible location. Well, you need to think about your employees. You have employees with disabilities that need an accessible environment in order to participate in the Christmas party. No, it's not an essential function of the job, but it's a privilege of employment that they should be included in. Something as simple as that. Those are the benefits of employment. And I know you're thinking that being here for this training is not a benefit of employment, but technically it is, right? We wouldn't want to exclude somebody because they have a disability. Okay, who can get accommodations? Applicants, of course, full and part-time employees, seasonal employees, and temporary workers who have a disability that's covered by the ADA, and who can perform the essential functions of the job with or without a reasonable accommodation. So even temps, if they have a disability, you may need to provide accommodation for them. It's a good idea for an employer to have a reasonable accommodation policy. I'm sure the county has such a policy, and to follow that policy when you have a request. It's up to the employee to notify the employer if there's a need for accommodation, but they don't have to use that language. I don't have to say, under the Americans with Disabilities Act, I hereby request a reasonable accommodation under Title I to perform the essential function. You don't have to use that language. You can say, I need help doing this. And maybe you need to disclose the disability in that situation because you're asking for something that is out of the ordinary. So I disclose the disability, request a reasonable accommodation. But it doesn't have to be in technical language. I can just say, I need some help with this. Can I get that? Right? The employer can ask for documentation. If you request an accommodation, they can request documentation describing the individual's disability and how the condition impacts the employee related to their job and the work environment. Reasonable accommodation examples include restructuring a job by reallocating or redistributing marginal job functions, altering when or how an essential function is performed. Again, the essential function must be done, but maybe we change how it's done. A part-time or a modified work schedule, obtaining or modified equipment or devices. Software often is, something that will allow them to continue to do their job, modifying examination, training materials or policies, or providing qualified readers and interpreters. EEOC says you should engage in the interactive process. Some attorney came up with that term, I'm sure. What does that mean? That means talking to the employee. Right? That's the interactive process. Have a conversation with that employee about what they need. After the employer is informed, something needs to happen in a timely manner. Both the employee and the employer play a role. Employees need to be prepared to discuss, how is this disability impacting my job? What are some suggestions for accommodation? They probably know what they need to do, to have in order to do their job. And they may have suggestions for resources or employer incentives. There are resources like the Division of Vocational Rehabilitation, the Division of Blind Services, some of the other agencies like BOLI centers that helps people with disabilities get jobs. We have resources that we may be able to pay for the accommodation that's needed. Certainly there are resources out there. And do some homework. The Job Accommodation Network, the ADA centers, Able Data, there's lots of assistance out there about how do I accommodate a person, with an amputation to do this job, or with a visual impairment to do that job. A lot of information is available out there about how to provide reasonable accommodations for people with disabilities, and including in state agencies funded by the federal government to help people with disabilities find jobs. Some accommodations are better than others. Leave and reassignment should be considered as a last resort. Providing leave for somebody who has a disability as an accommodation is a form of accommodation for individuals with disabilities. And there is some crossover with other laws. You may have Family Medical Leave Act come into play, where an employee needs to take leave because of their disability. And the Family Medical Leave Act actually could provide leave for someone who has a family member who's in need of them helping them. So there may be situations where, other laws may apply, where family medical leave may kick in and provide leave for a person with a disability who needs that, right? You could have an individual who takes all of their Family Medical Leave Act and gets to the end and says, I need additional leave under the ADA. That can happen, and they could get that. Again, though, eventually they need to be able to perform the essential functions of their job if they're qualified for the position. That makes sense? The picture on the screen is a set of stairs leading to a door that says handicapped entrance. I put that up there just for a little laugh, but I also want to just add as an aside, from a sensitivity standpoint, I don't use the word handicap. You will not hear me using that phrase. Handicap goes back to the Old English of cap in hand and labeling people with disabilities as beggars, basically. So we don't use the term handicap. The bathroom is accessible. The parking spot is an accessible parking spot. It's not a handicap parking spot, right? People with disabilities are people who have a hearing loss, people who have a mobility disability, people who use wheelchairs, people who are deaf, or people who are blind. They're not the handicapped. That's my 2 seconds of sensitivity from Jack. Okay? Again, the EEOC says we engage this interactive process, look at particular job functions and determine what are the essential functions, consult with the employee, consider the preferences of the employee, and select the accommodation that best addresses the need of the employee and the employer. They'll probably have an idea of what kind of accommodation they need, right? Typically, they're going to know what's going to help them. Now, it may be the most expensive accommodation that they want. The key is it effective? Is it an accommodation that is effective? It may be less expensive, but you're able to provide an accommodation that gets the job done. So, engage in that interactive process. And certainly, years ago, we had computer systems that had voice recognition that cost $50,000. Now, I have it on my iPhone, So a lot of things have changed when it comes to the technology available and what people can do to accommodate them. A lot of the things that used to cost a fortune are now routine. So do your research is the point there. When is it not a reasonable accommodation? When it is an undue hardship. And that is an action that is unduly costly, extensive, substantial, or disruptive, or one that would fundamentally alter the nature or operation of the business. Okay, so an undue hardship is something that could be too costly, but cost is on the list, but it's not the only thing on the list. It could be disruptive to the workplace. There could be other reasons why you refuse to provide the particular accommodation that the individual is requesting because it is an undue hardship and would fundamentally alter the nature and operation of the business. That could happen in various situations. The old example, which isn't going to be particularly relevant to you, but think of it this way. If I have a romantic restaurant, right? My business is a French restaurant. The lights are turned down low. It's candlelit. And I have a waitress that is losing her vision. And she requests that we turn the lights up. Well, that doesn't cost a lot, but it may fundamentally alter the nature or operation of the program. Paving the park, say you have an employee that becomes disabled and you're working in a pristine preserve out, in the park situation. Yes, you can provide accessibility to parts of that area, but not all of it, because it would fundamentally alter the nature or operation of what you're doing, right? In a park environment like that. I need to work on that example, but I think you get the point, right? Okay. An undue hardship means a significant difficulty or expense incurred and considered in the light of the nature and the cost of the accommodation. How much does it cost? The overall financial resources of the site or sites involved, the number of persons employed and the effect on expenses and the resources. The type of operation or the geographic separatedness or the impact of the accommodation on the operation of the site, the ability of others to perform their job, and the ability to conduct business. So some of these things could pose an undue hardship. When we're looking at the overall financial resources of Alachua County, it's going to be difficult for you to say it's too expensive to provide this accommodation when we're looking at the county. When we're looking at a small, what's a reasonable accommodation for the county is different than what's the reasonable accommodation for an employer with 20 employees. So you look at the overall financial resources of that site, of that employer. Okay? An undue hardship needs to be determined on a case-by-case basis. It's recommended that if you're going to deny a reasonable accommodation, that decision needs to be made at the right point in your hierarchy, in your management level. And consider alternative accommodations that do not create an undue hardship. So, look at other options. If you've ruled one out, is there something else that's less disruptive or less costly that would still allow this person to perform the essential function? And just because you've tried one doesn't mean you shouldn't try another or maybe a third or maybe a fourth attempt, depending on the situation, what the accommodation is. Is there a cost involved? Maybe there's no cost whatsoever, but this isn't working, but maybe we can try it a different way. You're not required to eliminate any essential job functions. That's never required. You're not required to lower production standards that are applied to all employees. You're not required to provide a personal use item like a wheelchair or a hearing aid or glasses. And you do not have to excuse the violation of uniformly applied conduct rules. And there's the famous example in Tampa. There was an employee who said he had a mental health disability and he brought a gun to work. And he was fired for bringing the gun to work. And that was a violation of uniform conduct rules. You don't bring guns to work. Even if you have a disability, that has no bearing on, bringing a gun to work. Doing things like yelling at customers or, engaging in arguments could be a sign of the disability, but it could also be a violation of the uniformly applied conduct rules. Make sense? Yes, you can get medical information. Employer only has the right to documentation about the disclosed disability. It should be job-related and consistent with business necessity, and all medical information must be kept confidential and separate from the employee work file. There are strict legal limitations on the use of that medical information. It needs to be kept separate. Share medical information only as an as-needed basis. So the fact that I'm getting a reasonable accommodation on my job and my coworker, who is not my supervisor, doesn't like it, well, that's not an undue hardship on the employer, right? And we don't need to tell that coworker, oh, well, Jack has schizophrenia and this is a reasonable accommodation because of his disability. Now, we do not need to disclose that information to the coworker, and the fact that they don't like that I'm getting an accommodation is not an undue hardship on the employer. Okay? Only on an as-needed basis. Talk a little bit about drugs and alcohol. The illegal use of drugs is never going to be protected. Alcohol is legal, and use is not automatically disqualifying. What I mean by that was, if I am a recovered drug addict, and I disclose that to my employer, and that could be a disability under the ADA. And I could request a reasonable accommodation. Say I want to attend a specific meeting on a specific date, and I request time off because of that. However, and because I'm a recovered drug addict. However, let's say you have information or the person appears to be under the influence after that, you can drug test that person right away and fire them if they are using illegal drugs, right? So the use of legal drugs, even though that person had protection as a person with a disability, but if they fall off the wagon, they're no longer protected. Alcohol is different in that it is legal, and you probably have, I'm sure the county has policies about the use of alcohol. If someone comes to work drunk, how you handle that. So if I disclose to my employer I'm an alcoholic and I need a reasonable accommodation to attend a particular meeting, and that is granted, and then, a week later, it looks like the person's been drinking, that's not an illegal substance. You need to follow your HR policies as you would handle a person who comes to work drunk. Make sense? EEOC has a bunch of helpful guidance on their website. This is just a list of some of them. So if you're looking for more information on the definition of the term disability or workers' compensation and the ADA and how those two play against each other, there's lots of guidance online. And I think it's time for me to take a quick break, right? I'm zipping along this afternoon. I'm a little ahead of schedule. Questions, comments on Title I? There's websites and numbers to call if you are looking for more information. This is my disclaimer. I am not an attorney and I'm not representing the federal government. I'm here simply to provide technical assistance and training. And that's my disclaimer. I'm not going to read all that to you. This is my contact information. So we'll take a 10, 15-minute break, and then we have another hour of Title II.